Hello everyone, welcome back to this channel. Remember, this is the only channel that provides you with insight of what palliative care is and approach to end of life. Before we start, I would urge all those who are watching this video, please subscribe, share, and like my videos. You can also leave a comment in the comment section. I usually reply to these comments because the ultimate goal here is to share knowledge, because knowledge is power. And today I will talk about palliative care and law, some aspect of palliative care and law. Remember, in palliative care, we have a multidisciplinary approach. Hereby we involve various disciplines or various professions in caring for our patients, as the ultimate goal of all these interventions is to ensure that the patient is comfortable and also we enhance the quality of life of that patient. And in law has multiple interactions with palliative care, and one of those multiple interactions is about succession. I know this is an issue that have affected so many people, because you tend to find that some patients may be diagnosed with life-limiting illnesses, but due to denial, they might not be willing to write a will pertaining of how their properties will be disposed. Others may get debilitated or may go even into coma without having made a will, and others may be fortunate to make a will regarding their properties. And a will not only includes properties, it can also include children, because you tend to find some of these patients, they leave back children who are very young and who might not be able to take care of themselves. So in this specific video, I will talk about disposal of properties and law of succession, and this is entailed in Cap 160 of our Constitution. And Cap 160 clearly states that an individual can die testate or intestate. An individual dies testate when he or she has made a valid will pertaining how his or her properties should be disposed. And an individual dies intestate if he or she has died without making a valid will pertaining his or her properties, or have not included all his or her properties in the will he or she made earlier. So I'm going to start with testate succession. And the law provides that an individual who is of sound mind has a right to determine and choose how his or her properties will be shared or will be dispensed in the occasion of death. And this determination can be based on various secular or religious laws. Remember, the constitutions also have provisions of how a dependent of this patient, if left out in the will, can apply for shares in those properties. And when it comes to testate succession, there is the issue of a will. A will is a very important document, and it is simply defined as a legal document that is written by an individual of how his or her properties should be disposed in in a situation he or she may not be living anymore. We have various types of wills. The first type is an oral will, and this will is made by a patient who can talk, and it is made verbally. But for it to take effect, there must be 2 or more sound witnesses when this patient is making the will. And also, after the patient has made the will, he or she must die within 3 months for that will to be considered to be still considered valid. If a patient makes an oral will and lives beyond 3 months, that will not be valid. And in that case, if the patient does not make another will, he will end up dying intestate. The other type of will is a written will. This is very common in most families. And a written will, it has the aspect of a signature of that patient or a fingerprint of the same patient. If a patient is debilitated and cannot be able to put a signature, or perhaps the patient has been amputated, he don't have a fingerprint, he or she may select an individual who will sign on her behalf, but this patient must acknowledge the signature of that individual in presence of 2 witnesses to make that written will valid. A will, as we have said, is a legal document, and it has different characteristics. The first characteristic is that a will is an expression of interest. Is an expression of interest of a patient wishes. What is written in the will, what is included in the will, basically entails what that patient wants after his or her death has occurred. And patient make these wills considering their interest or their maximum beneficence to them, whether they will be present or not. The other characteristics of a will is that a will is ambulatory. If a patient happens to make a will at this juncture and in the process acquires other properties, those properties can be covered in that same will because of that aspect of a will being ambulatory. A will is also revocable. If a patient decides that perhaps what he or she stated in the will is not satisfactory, he or she may revoke that will and go on to write another one. So why should we encourage our patients who are at end of life to make a will? A will is of importance in different aspects to the patient and to the family. And one of the importance of making a will is that this patient will still have some degree of control of his or her estate of property or properties even after death. And this basically helps to resolve the situation whereby The dependents may be disinherited the properties by greedy relatives. Remember, a will also helps to prevent situation whereby properties are lost by the family. Like for instance, a person may die and those close to him or her are not aware that he or she had a certain property somewhere or had a certain amount of money in the account. With a will, it helps the patient to state all his or her belongings, and thus prevents loss of these belongings by the relatives and those of concern to that patient. The other importance of a will is that a will basically helps prevent conflicts in families. Remember, properties and descendants or descendants of these patients, they will have different interests and specific interests in certain properties over the others. And if this patient made a will, there will be no quarrels among these descendants, because they will be aware of what each and everyone has been allocated to manage or to get from the patient. The other thing we should know is that it is only through a will that one can benefit a person who is outside his or her family. For instance, some people may want to extend a hand as a form of an appreciation to someone who eventually helped them during their difficulty time, but without them putting it validly in written form as a will, that person cannot inherit that property. The other importance of a will is that these patients are able to determine who will take care of their children in their absentia or in a situation whereby they are no more. And that is why I had previously stated that a will does not only include issues of properties, of physical belongings, but also of children. Remember, some children are left at a very tender age, whereby even making independent decision may be at times difficult. They need some guidance. So it is through a will that one can identify a guardian who he or she will delegate the duty of taking care of the children in an event that the patient has died. So that is about tested succession. So we go to now intestate succession, and as I had stated earlier, intestate succession, this is basically inheritance, or what the law states of how the inheritance of properties that the owner did not make a will, or perhaps did not include his or her properties or his or her properties in that will. And the law is very clear in this juncture, whereby it classifies this situation into two. There is a case of a monogamous marriage. A monogamous marriage, I mean a marriage that is made of one wife and one husband. And also there is the provisions in case of a polygamous marriage. A polygamous marriage is basically marriage whereby someone has married more than one wife and they have many children, for instance. So I will start with what the law states about monogamous marriage in succession. So in a case whereby a person had not made a will or had left out some properties out of his or her will, the law is state that in that scenario, the spouse is entitled to a lifetime interest of the belongings of that patient. And in belonging, I mean the households belonging and physical belonging. This law also provides that the spouse will have the right to pass these properties to his or her children when he or she may find that time appropriate. On the contrary, the law also stipulates that if in case that person, that spouse remarries, he or she automatically get disqualified from that lifestyle lifetime interest in those properties. So in case of a polygamous marriage, remember this is acceptable in some situations. So a polygamous marriage is basically a situation whereby a person has married more than one wife in a culture that is acceptable. We also need to remember that not all cultures that have accepted polygamy. So if we are saying we are polygamous, then our cultures should have dictates towards that. So in case of such a scenario, the law states that somebody who is married as a second wife is entitled to inherit part of the properties of an individual who had a polygamous marriage. And this does not matter even if that person had previous monogamous marriages. Also, the children of that spouse who happens to be the second spouse of that individual are entitled to get shares of their parents' properties passed to them by that second wife to that person. So it is good that if we suspect that our patients are approaching end of life, the engagement of law or of law professionals will be very important in ensuring that that person has peace of mind during that time. And again, it will help reduce conflict that comes as a result of property distributions. Remember, we are not only taking care of patients' physical well-being, and a physical well-being I mean management of pain and other symptoms. We also want to ensure that this patient is comfortable in all aspects, and not only the patient, but also the relatives and those who are of concern to that patient, the children, etc. So let us be vigilant in shedding light to our patients and those who are at end of life, or even our guardians or relatives who are at end of life, the importance of making a will. I know most people perceive that making a will is kind of sign of having lost hope, but that is a stereotype. That is not the case. Making a will is something that is of great significance, because it will help prevent a lot of detrimental issues that may rise up in the event of death of that patient. So let our patient understand what will is, what they entail, what laws of the land dictates how wills should be made, and what makes these wills valid. Thank you so much. Let's meet in the next session.